Well, good afternoon, everybody. Bill O'Leary here from Legacy Planning Law Group, coming to you on this Thursday, March 11th, 2021. Thirsty Thursday, it's time, part of our Thirsty Thursday series. And for those that maybe haven't checked in before, every Thursday at about this time, I'm going to come to you live talking about, a different topic from week to week that might relate to elder law, estate planning, wills and trust, and that sort of thing. That's what we do. So if you're thirsting for knowledge, you've come to the right place. Today's topic is why is estate planning more complicated with a gray divorce? With a gray divorce, I don't know if you've heard that term before. So a gray divorce really is it's descriptive of sort of a demographic trend of an increasing divorce rate among older people that maybe have been in long-term marriages. And in fact, a Pew study showed that since 1990, the rate of divorce among people 50 and over has doubled in that's 31 years, okay? That's a pretty significant change. Now, what are some of the reasons for gray divorce? Well, perhaps divorce has less of a stigma than it used to have. Life expectancies certainly have increased, and with increased life expectancy, there's a desire to try to live life to the fullest. I think also the fact that more and more women have entered the workforce than 30, 40 plus years ago and are able to take care of themselves and maybe in a bygone era, a wife sort of uh, felt that there was no option to divorce because they needed a husband who was the breadwinner. That's not the case anymore. And with an increasing life expectancy and sort of an equalization of being able to financially sustain yourself, maybe there are more opportunities now to find a sort of a more satisfying partner. Who knows? I just throw those out for your food for thought. But the fact is that if we're talking about a divorce by an older couple, when it comes to estate planning, they're more challenging issues because usually by that point in life, the estate plan that's been put in place is more complicated. Um, is more complicated than just starting out in your 20s or maybe the birth of the first child, and all you need is a will to make sure that guardians are named to take care of the kids. But as you get older, things become more involved as you have sort of acquired additional assets, amassed some money, perhaps a little bit of wealth, bank accounts, financial accounts, and perhaps you have a trust, so it gets more involved. So I want to talk about two things. Number one, what are the estate planning issues or items that are impacted during the divorce process? And then, secondly, what estate planning items really need to be looked at after the divorce is finalized? So, during the divorce process, the power of attorney needs to be looked at. Maybe you've named your wife as your agent under the power of attorney to make financial decisions for you, okay? And you don't really want him or her to be in that entrusted position anymore. So maybe you should take another look at that power of attorney and redo that. Same thing for healthcare advance directive. So the power of attorney, sometimes called a durable power of attorney, deals with financial matters. A healthcare advance directive deals with healthcare decision making, maybe a healthcare surrogate designation. Some may know it as a healthcare power of attorney. A healthcare proxy is a term that's used in other states, not here in Florida, but the idea is the same. Or maybe you've named your spouse as your healthcare decision maker, and you don't want him or her to be, again, making those decisions for you anymore. So you may want to take a look at that and redo that. What about your will? If you have a will, and let's say everything is going to your spouse, um, is there a need to change that? Is there a need to change that? Well, typically, there may be during the divorce process sort of a suspension or freezing of the situation, what's called sort of a restraining order that prevents both spouses from changing things up during the divorcing process in case somebody, let's say, passes away before the divorce is finalized. But still, at some point you're going to want to change your will. In Florida, there is a rule that says that upon the completion of a divorce, then to the extent that a will included your ex-spouse, that will, or um, that I guess that gift to your spouse is automatically revoked. I guess the law says, in the eyes of the law, it's as if your spouse passed away before you and doesn't exist anymore. So, that does help the situation where there's a concern. Oh my gosh, I haven't changed my will. I got divorced 3 years ago. Well, no, the will in that respect is okay. There may be another reason to update the will, but in that respect, not to worry. Same thing if you have a trust. So there's sort of an automatic sort of revocation of the spouse's role as a beneficiary in that trust, as well as to the extent the spouse is named as an executor under the will or a trustee under the trust. All parts of the will or trust that deal with the ex-spouse are sort of null and void. What about life insurance? Well, life insurance can pass at death, not through a will, but by what's called a beneficiary designation, where you can name a beneficiary of the life insurance. Okay. Well, just like with a will or a trust, any parts of it that deal with the ex-spouse sort of are null and void. Same thing if there is a beneficiary on the null and void. Now, a lot of times, as part of a divorce, okay, that's usually where there are children that need to be supported, okay, support element. Um, and so if there's a child support element, let's say the husband has been ordered by the court to provide child support. What happens if the husband dies before the kids reach, age 18? Well, life insurance is often a component to make sure that that money is going to get paid, and there are often attendant obligations to pay the premiums. And if, let's say, the husband has to take out the policy and doesn't pay the premium, then there are other mechanisms to make sure that premium gets paid so the policy doesn't lapse. But with respect to the divorce situation, again, the beneficiary designations need to be looked at. Same thing with retirement accounts. Okay, they can pass by beneficiary designation as well. I want to talk about two types of retirement accounts. One, an IRA, individual retirement account, okay, and two, a 401k that some may have at their work. The IRA, to the extent it is named a beneficiary, and if that beneficiary is the ex-spouse, again, that's null and void. Okay. Although certainly after the divorce is finalized, you really need to take another look at that beneficiary designation and update it. Let's compare the IRA situation to the 401k. I said that with the IRA, if the ex-spouse is named as the beneficiary, it's null and void. That is not the case with a 401k. That is so. If that ex-spouse is still on there, then that ex-spouse will get that 401k. Now, usually, as part of the divorce process, uh, each side comes to an agreement, and maybe one spouse is going to get part of the other spouse's 401k, and there often is a special type of court order that's put in place that's designed to sort of satisfy some federal law that applies to 401ks. That's called a qualified domestic relations order, QDRO, sometimes Quadro for short. But again, the important thing is 401ks are treated differently than IRAs when it comes to whether the ex-spouse named as a beneficiary is null and void after the divorce occurs. Okay. Now let's shift to, okay, great. The divorce has been finalized. What estate planning items should be looked at? Well, number one, update that power of attorney if you haven't already done it before the divorce is finished. Who do you now want to be your financial decision maker? How about your healthcare advanced directives? Who do you want your healthcare decision maker to be? Take another look at it and come up with a new decision maker and list of decision makers. How about your will? You really need to update your will. Even if the will names the ex-spouse and that part is null and void, you really need to update your will. And better yet, if you're an older couple that falls into this category of a great divorce, and now you're divorced, chances are you probably would want to consider a trust as an alternative to a will, and that's a separate talk to have, but a revocable living trust as an alternative to a will. Because why is that? Well, if you have wills as a married couple, and let's say you own everything together as husband and wife, the classic what are called I love you wills, okay? Honey, when I die, everything goes to you. When you die, everything comes to me. Well, at the first spouse's death, it's pretty easy. Everything goes to the surviving spouse. No need to get caught up in the probate court. Um, but once you get divorced, you no longer own assets jointly as husband and wife anymore, do you? No. So what would happen then if you pass away? Well, let's say your kids may very well find themselves bogged down in the court system. So at that point, you'd be well advised to talk to a lawyer about upgrading to a trust. And then the last thing to consider is, um, um, well, I had mentioned the life insurance and the retirement accounts. Take another look at those beneficiary designations. But the last thing is get a good estate planning lawyer on board as part of your team. Do you know anybody? Well, if you don't, give me a call. So anyway, I hope you've enjoyed this. Again, this topic has been why is estate planning more complicated with a great divorce. If you'd like to know more, or maybe how we can help, I would really invite you to book a 15-minute call with us. It's free. You can go to the Book Now button on the Facebook page. You can just call us at the office, 904-880-5554, or just Google us, LegacyPlanningLawGroup.com. And the purpose for this call is for us to sort of feel each other out, to think we'd work well with each other, and really to understand your situation, so that way we can tell you if we can help you. We don't want to waste your time if we can't. But if it's sort of estate planning, elder law, it's in our wheelhouse. We can help you. So again, I hope you enjoyed this. By the way, if you have, I'd ask that you like this video, and better yet, share it with your friends. A Facebook share would be tremendous. We're really trying to get the word out. So again, I hope you've enjoyed this talk about why estate planning is more complicated with a great divorce. As I said, next Thursday about this same time, I'm going to give another talk, different topic, same day and time, just a different topic. So if you're thirsting for knowledge, we will quench your thirst. So Bill O'Leary, signing off for now on behalf of Team Legacy, and I really want you to go out, make this a great day and a better world.